Oh, little girl do a good job. What she do?
Good evening, everyone.
Hi, David. So we have 25 of us here. I think we can start now. How is everyone doing?
Good, thanks. How are you?
I'm good, thanks. Did everybody get a chance to read this week? I know it was Valentine's and all of that stuff, but and everybody got a chance to at least look at chapter unit 3?
Yes, ma'am.
Cool.
Yes.
Yeah.
Yes, Mom.
Cool. So who wants to tell me one thing that they noticed about chapter 3?
It's very law-esque to me.
Eh?
Yes, I felt like I was like in a law class. I was like, what?
I noticed that it was comparing pretty much UK regulations to outside of UK.
Right. Ishul, your hand is up. Are you good?
Hi everyone. I have a question about the platform, the ICA, the course platform. So there are videos. I watch the videos, and after every unit, there is a section where it has knowledge checks with a lot of short answer questions. Have you guys seen it by any chance? Like any of my classmates?
Yes.
Yes.
Do we have a deadline to answer them, or who's gonna check the answers? My question is, what's the word count for that?
Ishul, they're not actually going to be checked by anybody. They're just for practice, to be honest.
Oh,
So when you go in your student's manual, you should see how they rate the word counts based on what's the point value for each question. But those questions are generally for your practice, so that when it's time for you to write your paper, you would be knowledgeable about the subject.
Okay, thank you so much. I thought they were gonna be graded. Thank you.
Okay, you're welcome. Anyone else notice anything with unit 3?
It also shows how much the UK legislation has evolved with time.
I found it very case sensitive. The chapter, that is the unit.
I'm just letting you all talk. I'm here, but I mean, it's 24 of us, so that's only 4 people who answered, and you're all right. This is an opinion-based question, but you're all right. So I'm waiting for the rest of you all. I am not going to speak for the 3 hours tonight. You all are going to participate as well.
Ms. Sands, I particularly enjoyed the Shaw case, the reading and the judgment, well, the decision. I found that interesting in terms of, what is it? In terms of disclosure and the level of suspicion. The threshold for suspicious activity, what is considered suspicious activity? And also how different countries such as Denmark and other countries view money laundering and what constitutes money laundering.
Okay, I like the suspicious transactions to find out that you as a officer who filed it, that you really need to know what is actually required or that your suspicion has grounds to stand on, because you then can be sued in turn for causing a customer's transactions not to go through.
I'm liking the answers. Let's go. Issue, your hand still up. What did you get from unit 3?
I'm sorry, it's not supposed to be up. Let me just lower it really quick. About unit 3, unfortunately, I haven't had the chance to read it.
Okay, so when you read it, then you could come to your conclusions, which will probably be similar to the other classmates.
Okay.
Anybody else? Thanks. Anybody else read it and wanna say what they thought?
I just wanted to say, I thought that with the way that the UK legislation is outlined, where you have primary, secondary, and then industry guidance, and even there, like there are different legislations like the POCA Act and stuff like that. It just seems that smaller jurisdictions like the Bahamas kind of mirror that structure. So that was interesting.
Well, you know, we are a Commonwealth, so yeah, it is how it's laid out for us as well, because we follow the same legal, you know, we're all common law countries, so we follow that same legal structure. Anyone else? Any of my lawyers talking?
What I also found interesting, Ms. Sands, was in relation to the POCA, Proceeds of Crime Act, the actual extent that it went in terms of criminal criminal possessions, like just by mere being in possession of I guess like items or whatever, such as a car or whatever, indirectly or directly, you know, could still be considered as being liable under the act. I found that quite interesting. The extent as to which money can be laundered and where a person would be deemed criminal under the ambit of the act.
Have you read the Proceeds of Crime Act 2018, the Bahamas one?
Yes, I have. I have, but Ms. Sands, are you saying in relation to it not being as extensive?
I think it is very extensive.
I'm just asking. Yeah, I'm just asking.
I think it's similar in nature, to be honest.
Yes, it is based on the UK on POCA. Yes.
My attorneys, where y'all at tonight? Don't make me start calling your names.
Sorry, I'm here, but I also have baby as well who kind of screaming, so I don't want that on the recording.
Okay, but it's like 10 of y'all in this class, so I can excuse you, Joey. What happened to the rest of them?
In reference to the criminal conduct, right? When they were speaking on for the UK, it constitutes criminal conduct when they're saying the definition of it. And any part of the UK, they would consider it a criminal offense. And then it was like, we're any part outside of the UK, as long as even if it didn't happen in the UK, long as if it had me confused. Let me see how I should word it. So it was saying that if a criminal offense happened outside of the UK, they were treated the same as if it had happened in the UK. That I was reading that under the definition of criminal conduct.
Okay, but that's in relation to what precisely? What are you talking about? Because you know some of their laws are extraterritorial, so it's in be more specific in what you were saying. Because you know sometimes you have the best way I guess for me to explain it would be like, you know, when you have your AML, well, the central bank guidelines, and they talk about countries with the same level of regulation. So you could kind of use them for your AML, almost like eligible introducers. So in this case, I'm thinking you're talking about if the crime is almost, I guess, equal and under the UK, if it would have happened, or similar, I should say, if it happened in the Bahamas, because you know, the UK is head of the Commonwealth. So in a lot of times it could be in relation to if it happened in another Commonwealth country and it's a crime there, it'll be considered a crime in the UK. Is that what you're talking about? Is that what you're referring to?
Yeah, it was also stating that, in a sense, they was looking at it whereas like, if it's not a crime inside of the country outside of the UK, but the UK deems it a crime. And in reference to like, what it's not just money laundering, because I know they outlined certain specific things, whereas they were speaking to what they were considered general all across the board, like kidnapping, I guess, all across the board. But there was some differences between, whereas this wasn't a crime in a country, however, but the UK was still holding it as a crime under the UK legislation.
Yeah.
I think it was a case on that with the bull or something. He was a trainer.
Yes, and then they were saying that he was, I know what you're talking about. I saw that somewhere, and pretty much because it happened where he was, it was considered one thing, but had it been in the UK, it would have been considered, I think, a more heftier fine.
So he actually was going through it as a suspicious transaction, as if he is laundering from the UK perspective.
Right.
But
and it was awful in his jurisdiction.
Yeah, the conduct was not criminal in the country where it took place. It is known, yeah.
It was speaking to the difficulty in really defining money laundering.
Criminal conduct, right.
I found.
I'm just trying to turn to the page that Alicia put in the chat. Give me 1 sec.
It's on 92 to the top.
Yeah, 90.
The conduct can be committed anywhere and it's regarded as criminal conduct.
Yeah, because the criminal conduct is on 92 and then the bull case is on 93.
Yeah.
For those that are following.
Okay.
Why does our page number?
It's under definition of criminal conduct. I guess section 3.2.
Right, so that was what I was referring to as when I spoke about similar, like it might not be a specific offense there, but if it's similar, if it's committed, you know, someplace else and it's similar, then it could be defined as criminal conduct. But that's obviously the legal side of compliance. Anybody else came up with anything out of Unit 3?
I what was interesting, I didn't get to read it all, but what was interesting is that like in order to you just it almost like I want to ask the question, where does it end? Or does it end? Like in terms of the extent of, what's the term, predicate offenses. Like it almost seems as though in order for jurisdictions or these various entities to combat money laundering and so forth, that it's I won't say it's a losing battle, because that's too negative, but you have to find a way to stay one step ahead of the criminals, but that's very difficult when corruption is at so many levels.
And to piggyback off of that, I never, I guess, thought about it on the other end of the spectrum, I guess. I guess the lawyers could speak to this. I guess I never thought to think that, you know, if I hire a lawyer, the lawyer can pretty much tip off that they're trying to help me with this case, whereas sometimes saw something was filed. I only deal with it from the compliance end, but reading that, it opened my eyes like, yeah, well, this lawyer have to be exempt from the, you know, from quote unquote tipping off and being fined for tipping off, or being, I guess, expected to let someone know that they know this information because it's their job to protect this individual.
Is that the same thing, Alicia, where they say accountants are not protected?
That was further on down under a different thing. This one here I'm talking about is the whole thing with tipping off, when it's saying that you're expected, that if you get any information and you're expected to, I guess, disclose this information. So not tipping off. This was after tipping off, when they were talking about disclosing this information. If anything comes to you, you know, you're responsible to bring this information to the authorities. But who are exempt from this, of course, are the lawyers, if they are, you know, dealing with this case for their client.
Remember, they have privilege and client attorney privilege. All my lawyers quiet tonight. Y'all ready for me to start calling y'all names? Eh?
Well, I found it interesting. This was the part on the offenses for failure to disclose, where it talks about how the POCA provides defense for employees. I found that very interesting. Defense for employees who are in the regulated sector. So those who did not know or did not suspect that a person was engaged in money laundering, and they had not been provided with any training. And so it provides them with the defense because they didn't have that training. And it also provides those who are not in a regulated sector, who did know that there was money laundering but did not disclose it. So it's kind of like, right, yeah. But I found that very interesting.
So this is why, Rashada, every regulated financial institution has to do annual training. So unless you came in after the annual training was done and this thing happened before the next annual training, that's your only way to get out of that. So in a law firm, it may be different, but in banks and trust companies, when you come in, they give you a pile of things to read. One of them, apart from the employee handbook, would be the Aml Manual. So you would have to read, confirm, and sign and or attest to the fact that you've already read all of this information at some point. Most companies would give you a 30-day window to read all of them and hand back the attestations to the HR department. Once you've signed that you've read it, even if you haven't had any training, that puts you on the hook. However, if you are in a compliance department and you haven't had an opportunity as yet to have the annual training that's provided by the institution, that's the only way that you could use that as a defense, because you cannot expect someone to know something that you didn't tell them, yeah? But other than that, you are on the hook for everything else. And this is why annual trainings are so important. Central bank, when they come in to do inspections, they ask you for your staff training logs. And because it's mandatory, there's no line taking it, because I am in this department, the entire staff from the messenger to the CEO and board members are expected to have annual training in AML. And they are very specific with the laws that have to be, I guess, trained, the laws that you use to do the training with, and the process of crime just happens to be one of them. So annually, you're gonna know what you should and shouldn't do, and what you should and are not responsible for in your institution. I think the attorneys are getting there slowly with the Compliance Commission, because I think they're starting to put some pressure on y'all to do some things. So it's coming.
When I
Yeah,
read
'cause
that,
that's not done in law firms, but obviously I've switched over from a law firm to a financial institution. And so I've had my first, I guess, encounter of a risk and also a compliance meeting, which, like you said, included even the CEO having to sit in on those meetings. And so, yeah, that's something I never done in law firms, but certainly I experienced that for the first time in December, sitting in those meetings.
It's coming, David, to the law firms, because I'm getting requests to provide training for law firms, because now that they're under the Compliance Commission, especially if they offer any type of financial, service to their clients, it's coming.
Yeah.
I've also noticed that more and more law firms are in fact, undergoing this. Like in the past, it wasn't as prominent, but more so now. More law firms, that offer financial services do require this training for all of their staff members. I'm referring like from the bottom straight up, literally. So I kind of agree there.
It's mandatory, Rodrigo. They have no option. It's no longer an option. They have to do it. They've been brought into the AML framework, and it's mandatory. Like I said, I know because I'm getting requests to provide training for law firms, which has never happened before.
I was even going to say, I hope I could say this, that I did a compliance audit for law firms. So I actually thought this was like the norm, where one of the questions where they asked, when was the last time your staff did any AML training? Was it international? Was it local? And stuff like that. So I kind of thought that was the norm. So this is interesting.
The training is normal because every institution is expected to train their staff. But the specific annual training to which I'm referring is just coming on board, I think, in the last 2 years. For the attorneys, so for all of those persons, well, any licensee or registrant under the Compliance Commission, that's just coming on board. And the pandemic pretty much kind of threw it off course for the last 2 years, but right before the pandemic, yeah, that's been mandated. They're mandated to have MLROs, they're mandated to have the annual training, they're mandated to have compliance manuals that reflect the business that they are in. So we're all being brought under that AML Cftpf regime. We off the blacklist, we need to stay there. And so they definitely, all the DNFPBs had to come under that regime.
I think it's good, Ms. Sands, that is actually mandated because, I mean, with the extensiveness of just money laundering and just like those kind of fraudulent crimes, I just think it's a good requirement, especially how the times are moving.
Yeah, we have to ensure to stay off of the blacklist. We have to ensure that the entire sector is under an AML Cftpf regime, right? So we just can't have anybody operating outside of that framework. And so that's why they're now being brought into that regime. Okay, so most of you would have said what I was thinking as it relates to Unit 3. Unit 3 is definitely UK focus centric. A lot of it you need to know because you're doing this course, and this course is obviously being, you know, it's out of the UK. However, as it relates to writing your papers, the question speaks to, you know, dealing with a jurisdiction with which you are familiar. Unless you have a lot of familiarity with the UK, most students use a jurisdiction that they know. You know, if they know about Cayman, if they know about the Bahamas, and the like. So what you would need to do is to ensure that you know and recognize all of the things in the Bahamas that is being spoken about in this unit from the UK. So yeah, they talk about the UK poker. You have to know Bahamas poker. They talked about, you know, the whole regime in the UK and Guernsey and Jersey. So you have to recognize that, yes, this is knowledge. However, as it relates to the assignments, you have to be very versed in the Bahamas's legislation and the Bahamas's rules and guidelines from a regulatory perspective. Yeah?
Yes, yes, ma'am.
FATF is global, so we spoke about that, I think, last week. We all need to know what the recommendations are because it's just not a thing specific to the UK, it's global. So when we speak about FATF, the recommendations and things like that, we know that this is a global minimum standard, yes?
Yes, ma'am.
So can somebody read the learning objectives for me, please?
The purpose of this unit, the learning objectives, were to examine how the legal AML CFT framework has developed in the UK, discuss how primary legislation is supported by secondary legislation, guidance documents and regulatory handbooks, to consider the frameworks of the offshore centers of Jersey and Guernsey, and to briefly consider the frameworks in various European countries.
Right. So if we go to section 1 on that, we will see where they're starting off with as it relates to the international AML CFTPF framework, right? And like we said earlier, a lot of this has to do with what's going on in the UK and in other parts of the world. So Nisha, I'm so happy you're here today because the rest of the people don't really talk as much as you. So let's talk about FATF recommendation 3. It's an extract, but it speaks to money laundering and what the offense is. So let's talk a little bit about that, and then we can just go through the book as. When I say let's talk about that it means I'm open to conversation. Can you hear me? I'm seeing that my internet is unstable. Can everyone hear me?
Yes, we can hear you.
Yes,
Okay.
we can hear you.
Yes, we can hear you.
Yes, we can.
Okay, so when I talk about FATF recommendation 3, let's talk about that. Let's talk about what it says, the development of domestic anti-money laundering and counter financing of terrorism models. We're having a full-blown conversation tonight. Let's go, people.
Well, they pretty much just saying that countries should criminalize money laundering, that it's a heavy offense that should be brought before the courts.
Yes, ma'am. Let's go, people. Felicia isn't the only person in class tonight. You don't have to be specific to word for word what the book says, but if you've read it, then you would know, you could be able to engage in the conversation.
And then they have
We're going through section 1.
They have 3 different frameworks, I guess. Someone mentioned it earlier, the primary, the secondary, and then the industry. Whereas the primary deals with laws. The secondary deals with the regulations, and then the industry guidance pretty much talks about the approved regulated authorities in the different industries. So I guess that's the 3 different layers that are taken into consideration when dealing with money laundering.
Under that primary legislation, they have a lot of acts, like the Criminal Justice Act, Drug Trafficking Act, the Terrorism Act, Proceeds of Crime Act, and all of these acts speak towards anti-money laundering.
Yeah, you're all right. I'm waiting for the rest of the people to contribute. We are flowing in the book tonight. Let's go, because a lot of this is not Bahamas centric. So let's just have the discussion. Let's flow.
They kind of said what I was going to say too, because I had messaged you about like trying to figure out what would be considered a primary or secondary legislation based on the Bahamas, since this is so UK focused. And I went on, I don't know if everybody know about it, Bahamas laws. And they had like different things where it would be considered primary, like he said. I think I messaged you about the FTRR and the FTRE. And statutory instruments or codes or orders, regulations and rules would be secondary legislation, like the anti-terrorism regulation of 2019. So it made me actually had to go do more research to figure it out, since I didn't know or was aware of these things. So it was definitely an interesting read.
Then it spoke about the different jurisdictions, whereas the Bahamas would fall in the former British Crown colonies of the overseas territories. So they pretty much broke it down into 3 different categories to say where these different countries would fall in. They grouped them.
And even in grouping them, I think too, in this unit, what they appreciated was the fact that some countries or some jurisdictions may be regarded as high-risk jurisdictions, or those more susceptible to persons wanting to commit the crimes of money laundering, so to speak.
I just wanted to say with going back to the primary, secondary, and industry guidance layers of legislation. I noticed with the primary, it's more of what you should do or what you can't do, the actual law that governs the AML space. And then the secondary legislation, which is more like rules and regulations, they are more procedural in nature. So I think they expand the requirements in the primary legislation. So for example, I guess what procedures should be taken for customer due diligence, or the requirements of the transparency for beneficial ownership, enforcement of sanctions, and so on. And I guess the third layer, which would be the industry guidance, would be like guidelines and handbooks that further, I guess, explain or detail what kind of policies or procedures can be done or implemented to ensure that the requirements under the secondary and primary legislation are carried out.
I agree, Nicolette. Anybody else?
I mean, presumably is the guidance itself non-binding? Is it just guiding, like what we see from like the central bank and stuff like that, those guidelines? Because I understand, primary legislation being, the law itself, secondary legislation being so more kind of the, I guess, practicality of it. But the industry guidance, I guess, would be non-binding, correct? Or just like the guidelines that we see from the central bank?
I thought the guidance was based on the first two steps, the primary legislation and the secondary legislation, to make sure that companies are following through.
Actually, they say that they are non-binding, but they in essence have the force of law behind them. You do not want to breach any of the guidance. They have the force of law behind them, even though they're not acts.
So, Ms. Simmons, in practice, it's binding.
In practice, it is binding.
Wow, and they just guidelines. Wow.
Right? So think about it. If you breach enough of central bank's guidance or SCB, something gonna happen to you.
License revoked, or you get heavy fines to what institution you're in.
Yeah, the penalties, breaches.
So isn't that binding?
Yeah, it has the effect. Yeah.
It has the force of law behind it, even though it's not a law. Yeah. So if you're a licensee, it would only make sense for you to do what is necessary to ensure that you keep your license.
Okay. Guidelines.
Yeah. So it's not a primary law like the proceeds of crime would be, but the force is there. The force is there because they are the ones charged with ensuring that the industry is at a certain standard. So the UK has legislation and strategy, as do the Bahamas and most other countries. Make sure that you know what it says and you know what the regime is all about. They also have the framework, like we're speaking now, the primary legislation. They have the substantive offenses of money laundering under the Proceeds of Crime. Now, their Proceeds of Crime Act is 2002. We have a Proceeds of Crime Act in 2018 that is very, very wide. And I think I would have said on the first class that we had, that's something I wanted you guys to read. Please ensure that you are very familiar with the acts that govern the industry in which you would like to work, which means you need to be familiar with the FTRA and the act and the regulations, the Proceeds of Crime, all of the acts that the Anti-Terrorism Act, all of the acts that would govern the financial services industry. You can go on the central bank's website and you can look up to see in their AML guidance, it tells you all of the acts that the guidelines are written on. So you need to familiarize yourself with that because a lot of times we don't think that, these things are criminal or whatever, because you probably see them as white collar crime, but crime is crime nonetheless. Fraud is a big deal. Cyber crime is a big deal. So you definitely need to know, in addition to money laundering, right? You definitely need to know that what the laws are for the industry in which you are working or you would want to work. Yes?
Yes, ma'am.
Yes, ma'am.
There's an offenses of failure to disclose. We have the same offenses in the Bahamas. A lot of things are very similar. You should know exactly what it is that you are working with and working under. If you are regulated by the SCB, the ICB, the Compliance Commission, the Central Bank, there's no excuse for not knowing the laws that governs the industry in which you work, and knowing the provisions, especially if you're going to be in compliance or AML or risk or fraud, any of those departments, you have to be aware. We all know about the offense of tipping off. Even the average man on the street, for the most part, knows that there's something called tipping off. They may not be sure what it is, but tipping off is an offense. Somebody explained to me what tipping off in financial services.
Pretty much if I work in the financial service industry and it was brought to my attention that we are going to investigate a client or investigate a transaction, and I know who the person is, and I pretty much tell the person, hey, they investigating this transaction, or I just give them any type heads up that there's some type red flag in regards to his account or his transaction.
What if you don't tell the person directly? What if you tell an agent?
If you tell, yeah, if you tell anyone really now, there's some, I read somewhere else that if you tell someone within your industry, it's not necessarily tipping off, but you just shouldn't, if you tell it to anyone really, because that other person could get it back to the individual themselves.
I think sometimes this person intentionally advise, they would tell someone they know to get the information back, and they're of the belief that is not the case, because I didn't go directly to the one that we're investigating. I told a neighbor who was my friend, or I told a colleague who was a cousin or something like that. So they're of the belief that that is not tipping off, but it actually is.
Part of it is if you have knowledge, and if you have knowledge and or you would have been the person to submit an FTR, it ain't even about telling the person. You are not supposed to disclose that information to anybody who does not need to know, which would mean more than likely you would say to your senior management what you are doing so that they can be aware. But other than that, you shouldn't even be telling other people in the bank or other people in your institution, because STRs are confidential, like everything else should be confidential. However, those reports are on a need to know basis. Yes?
Correct.
Yes.
Yeah.
Any of my attorneys, I'm sure you all have to write STRs, at least. You may not have written one before, but I'm sure you are under that same regime and framework where if it becomes necessary, you have to write one. Y'all want to tell us how it works in the firm?
Well, I've never had to do one before, and so I don't really know the process from a law firm perspective. Maybe someone else does, but I don't know how it works in a law firm.
Ms. Sands, I'm really not familiar how it works. Yeah, in the law firm framework, like David said, I never saw it. I know FIU, they deal with that, but I don't know how it works per se.
We have
Yes,
some other attorneys.
I've never had to write one. I've never even had to think about writing one. That's usually something that accounts and compliance deals with.
I've
Yeah,
never
you-
had to write one either.
The person and-
I've never had to write one either. I imagine that the MLRO or the compliance officer would be outrightly responsible for that.
Right, but even if you didn't have to write one, so Rodrigo or Rashada, what about contributing to one? Have you ever had to report somebody, one of your clients, to the MLRO? So, because if you've had to do that, then you would have had to submit an internal report. So even if you didn't write the report to the FIU, have you ever been in a situation, you don't have to say what the situation is, but in a situation where you've had to write a report or specifically or verbally speak to the MLRO about a situation, one of your clients that you thought, did a suspicious transaction or was trying to do a suspicious transaction in the firm?
Well, for me, fortunately, I've never had a situation like that where I had to report any client.
Me neither.
So far, I've had, I guess, very good clients, but I've never been in that position before, or at the very least, heard anybody have to be placed in that position, although I should not hear about it, as you said, because that would be tipping off. but I've never been in that situation before.
Years ago, I had a client who was a very senior person in one of the very important ministries. And the only thing I remember, I was called by head office and I was advised that she was under investigation, and under no terms was I to act differently or share what they were telling me with any of the staff. I can't remember exactly. I think she was transferred from the area that she was in. But I don't know I don't think that any charges were brought against her. And I at that time, I have a feeling, well, it almost seemed as though it was probably because of the position that she held. But that was a long time ago, before there was sufficient teeth in the anti-money laundering laws.
Mm-hmm.
Yeah.
Mm-hmm.
Anyone else has had any experience with STRs? Writing one?
Well, in the bank, we prepare those, honestly, I could say daily.
That's the joy of retail banking.
Yeah, we prepare those, and I've even seen instances whereas it was raised on staff.
Mm-hmm.
And see that in that case, it really gets, I would say, messy there, because as much as we want to say that you're not supposed to, because you work so close knit together, it's like they tend to think of it as, oh, it's just general conversation by the printer, I would say. Like it isn't something whereas everyone will be quiet. If someone file a UTR on a well-known customer, I promise you, every other person in the bank would know that this what Mr. So-and-so is dealing with. But now even I was not under the impression that that was wrong. So now even sitting on the call here, I'm like, oh, that's wrong for me to even tell my coworker I did that about another client. But if, especially like on a teller, if you're a teller on a teller lineup, you see these customers frequently. So everyone know Mr. So-and-so coming into the bank and he's sending a wire this week. Girl, I just had to file a report because he sent that. So it'll be big topic of discussion, but I never knew that, hey, that was wrong. I thought it was wrong if it ever go outside of the bank. But now to say that inside of the bank is still wrong, that's something I learned new today.
So, Mr. Brown, they never teach you that in your annual training that you are not supposed to have those conversations with anyone?
When we do the trainings from, because we usually take a lot of manual courses online, and then I guess it's based on how you understand it to be. I never took it that, hey, me talking to a coworker, letting a coworker know that it would be considered tipping off. But it makes sense now, because especially like how the Bahamas is only so big. You don't even know if you're talking to that person cousin. You don't know if you're talking to that person niece.
Mm-hmm.
It makes sense now, but you sign off on these things so much that I don't even think a lot of people stop to really understand it and understand the importance of it. How important it is. So even you'd find it in a bank, they sign off on those things every day. I really don't think everyone sit to understand it. Hey, what comes behind this and why am I doing it? Sometimes it just become a routine, to be honest with you, because the bibs come in your face every day. So sometimes it just become a routine. Some people probably don't even read the bibs. They just sign off on them. But now you see the bank is doing that to safeguard themselves, to say that if anything hit the fund, you sign off to say that, hey, you understand that.
Right, so now you're gonna go back and you're going to be the crusader for tipping off because it is an offense, okay?
Yes.
Wow, yeah.
So we on the section 4, the UK framework secondary legislation and regulation. What do you think that is, the equivalent of that is in the Bahamas?
The secondary.
Besides, you broke up for me. Could you repeat the question?
Oh, sorry, I said the UK framework secondary legislation and regulation. What is the equivalent of that in the Bahamas?
Any AML or terrorist financing regulations? So.
Agreed.
Oh.
So what are they?
Would it be the central bank?
Pardon?
Would it be the central bank?
Financial transaction reporting regulations?
Yeah, no, it won't be the central bank. The central bank is a regulator. So
The
yeah, the
Anti-Terrorism Regulation 2019.
we get more than that. That's only 2.
Secondary legislation often fulfills regulations.
Does this mean you all ain't read pages 108? And so you can have a comparative analysis of the Bahamas? Is that what I'm gathering?
I read 108. I just don't have the name on hand. Bahamas.
I read it.
You're looking for the exact names, correct?
Yes, ma'am, because if you're going to answer a question related to this, you're going to have to use the Bahamas's exact name, right?
Yeah.
Hey, good night. As I was reading this section, I was starting to pretty much jot down some of the laws that would relate to the Bahamas. And some of those would be like the Anti-Terrorism Act. They have the Banks and Trust Company Act, the Prevention of Bribery Act. Am I on the right track, Ms. Sachs?
You're talking about the primary, you're on the right track, but most of those acts have regulations that accompany them, right?
Yes, ma'am.
Sorry, I was talking and I went right. There was a guy last class who read one, the financial intelligence transactions. That's a regulation, a secondary legislation.
A lot of the acts have regulations that go along with them because the acts are for like, Rashida them, the straight out legal stuff. But the regulations is like for the industry that tells you how to do these things. And then the guidelines is more specific on what the regulator expects from the licensee. You see it? You see how it works? So the lawyers write all of those things, and then, most of us lay people don't understand none they be saying in them acts. And so the regulations that accompany them are for us to kind of understand, for them to break it down for us. And then the regulators come behind them and issue guidelines and notices and things of that nature. You see how it works?
Ms. Sands, just for clarity, are the guidelines more for interpretative purposes in the sense of how someone who reads the act should read it, or the regulation should read it?
No, I think the guidelines is how to get it done in your day-to-day. Because if you think about it, if you ever call the central bank, it's rare that they're going to tell you this is something that you have to do. Because remember now, we're using a risk-based approach based on FATF, right? So the guidelines is the parameters in which institutions can work and operate. Because if I'm a 2-man shop, I can't be expected to have the same level of everything that a 50-man shop has. So the guidelines are there for us to be able to work within a specified framework but we're all meeting a minimum standard based on the risks involved in the institution or the firms in which we work, because it's all risk-based. When central bank comes, they tell you have to do a risk-based assessment for your institution. SCB tells you the same thing, right? So your risk-based assessment is not going to necessarily look like mine, because it's specific to the product we offer, specific to our geographic location of our clients, all of those things. It's very specific. So the primary, secondary, and the guidelines work hand in hand. It's like they build on one another.
Okay.
Anybody else have any?
Another
any
one is
comments
oh, sorry.
No, go ahead, go ahead.
No, I was just saying another one, another example of primary legislation is rules. So like the financial and corporate service providers, AML, CFT rules.
Because they're specific to what you have to do in that space. If you have that license, that's what you're required to do. Because those rules are rules that you have to follow.
Right.
So who knows anything about the FCA in the UK? And tell us what you know. First of all, tell us what FCA means, and then tell us what you know.
Financial Conduct Authority, but with that, I think it's more like a handbook for the various financial industries to be guided by in a practical sense. So I feel, Ms. Sands, the effect is like law, like a poker, but it's more like a handbook guide.
Now, Denisha, you throwing me off. What you mean handbook?
No, I mean, no, it's not, I wouldn't say, I mean, I could be wrong, Ms. Ann. I wouldn't say it's a primary, I wouldn't say it's primary, but its effect, it's like, it's primary within the industries that it works or takes effect in.
I can stick a pin right there. Anybody else?
It's just another regulator. So it's just similar to the central bank and the Securities Commission in a way. And so they regulate the financial service industry in the UK.
You say just another regulator, very blasé. It is the regulator.
Well, I was just trying to do it to compare it to like the central bank and
Agreed, but you see, we have we have central bank, we have SCB, we have ICB, we have compliance commission. They are it.
Oh, okay, right. I didn't know that.
Yeah.
They are it. So a lot of
it's like a combined or amalgamated regulator, huh?
We normally call them like a super regulator.
Okay.
So they have like twin peaks, their regulatory system, but the FCA is where, like how central bank is with SCB, we think, I mean, for the most part, central bank, we look at as being, I guess, more wider than the SCB, because the SCB only focuses primarily on investments and securities, and now like crypto and all of those things, whereas the central bank's remit is much wider. That's how the FCA is. So they are the super, it's not just financial services. They also responsible for the consumer part of it as well. Like how central bank now has an ombudsman, which is also responsible for the consumer side of it. That's what the FCA is in the UK. So
Can you
Jersey has,
explain the ombudsman role, or what does it do exactly? How does it function?
That's a
well,
mediator.
it's not actually functioning at the moment. It's a new role that the central bank has rolled out. And the primary objective is for consumers to have a place to go to complain against, obviously, financial services institutions that they work along with, right? And at some point, I think it is the central bank's intention to include not just only the central bank, but obviously like the insurance commission and everybody, like all of the regulators. But for now, it's starting with the central bank, because when we complain, not this class, but another class of mine, last year, we were complaining about how, and I'm not going to talk bad about any banks tonight, but you know, when Royal Bank decided to take out the $20 out of the ATMs, right?
I hated that.
We just needed, we made noise, but we didn't have a specific place or person to go complain to. We went, obviously people went to the central bank. The central bank had, they issued a statement on it. However, Royal Bank has since brought back the $20 to some of their machines. However, the ombudsman would be somewhere where if you have a grievance specifically, let's just say you have all your loan receipts, you paid off your loan, but the bank is telling you that you haven't, you have a specific office that you can go to and complain, and they will mediate the situation for you. So that's the role of the ombudsman. It's a new role. It's just coming out, but hopefully it morphs into where the governor sees it should be, because it's something that the governor is definitely committed to ensuring that we have in this environment, because we have a lot of complaints about retail banks, about paying the fees exorbitant, or how long it takes to get your money back if something happens. But consumers themselves don't have nowhere specific to go. And so like how the FCA has the consumer protection aspect, this is the consumer protection aspect being headed up by the central bank. Understand, Ms. Farrington?
Yes, thank you.
Cool.
Ms. Sands, just to be clear, you're saying that their ombudsman process at central bank is more having the ombudsman in terms of like the FCA?
No, I'm saying the FCA covers like consumer protection in the UK, right?
Right.
So this ombudsman role, the office of the ombudsman, is there to do the same thing.
Okay.
It's all about consumer protection.
Okay. Okay.
And for the consumer to have, if you have a grievance with any one of your banking institutions, you pretty much where you write, you complaining to them. But if it's against them, a lot of times you feel frustrated because you know they have a complaint process, but who actually stands up and fights for you? And that's the role of the ombudsman, to bring the two parties to the table and try and get a resolve. Because most times the financial institutions, I mean, and they win, right? You complain to them about them. So most consumers feel like they're not getting what they deserve.
A remedy or a cost. So it's like calling the police for the police, in a sense. But there's the ombudsman. Okay. All right.
So you have an intermediary. You have somebody to kind of arbitrate. It's almost like an arbitrator.
Okay. Mediation.
But because they sit in the office of, because they sit in central bank and it's a office, it has some seats, right? And because the central bank is the regulator for the retail and offshore international market, where it is the best place for that office to sit, because that's the licensee. The central bank is the regulator that gives the license. If you have an odd against the licensee, who better to go than the person who gives them their license?
Right. Okay. Okay.
So it's a fit, and it's similar to what the FCA does in the UK.
Okay. Okay.
Okay, so Section 5 speaks on Jersey strategy on money laundering and terrorism financing. You guys need to read that. It talks about the supplemental legislation as well. I think I passed the section where we talked about gaming. We have any gaming board licensees in this class? Should I take the silence as a no?
I don't think we do though. Ms.
No,
Ann.
I don't think. Island law, anybody?
I didn't hear you, Denise.
No, I was saying island law, anybody? I don't know. I'm not.
Okay, I guess not. But the gaming board is also the regulator of all gaming activities in the Bahamas, right? Gaming, gambling, whatever you want to call it. And I can tell you, because I've had the fortunate pleasure of being licensed by the gaming board at some point in my career. To me, this is my personal opinion, they are the strictest regulator in this country.
What?
Really?
What?
Yes.
I wouldn't think that.
How so?
Nobody ever thinks that.
I would never think that. Wow.
Yeah.
Wow.
Because they have.
Sorry.
Because they have.
How?
First of all, they have a lot of power. That's the first thing. Second thing, when they license you, Denisha, put your thing on mute because I'm getting a feedback. When they license you, the process that you go through is like none other in this country. So you get licensed as an individual if you're working in a gaming house or a casino, right? Especially if you have a senior position. So I had a director position at a resort that has a casino. And I can tell you, the application was 83 or 84 pages to start off with. Then the background check is like none other. Then you have to give them 20 years of your life history. That is the first time in my life I have had to get fingerprinted to have a job. I'm talking all 10 of my fingers. So that process to me was like, whoa. And I've been in the financial services industry for more than 25 years. But they have, because they regulate such a high risk industry, they have what I would consider to be real powers. They can go into any gaming house at any time and request to see whatever information. You actually have to tell them what you're doing. They have employees that actually go into your gaming houses and your casinos and watch you count your money. They are that thorough. They don't wait for no time for inspection to come visit. They could pay you a visit at any time. In both casinos, actually in the 3 casinos in this country, you have a gaming board representative, an office on the gaming floor. So they can walk right out of their office onto the casino floor and ask any questions. Ain't no other regulator in this country as tough as them, none, hands down. And I've been regulated by the top 3.
Ms. Sands, why you think that is so? Why is it so conservative, so rigid?
Because gaming is high risk.
Okay.
Think about the money. Think about how it's done. Think about the fact that just a couple of years ago, it was completely illegal to be done by Bahamians.
Yes, yes.
And there was a process to convert that entire industry into a legitimate industry. So in order to keep the, I'm trying to be careful with the word that I choose here, the integrity of the industry, you have to ensure that there are very, very few loopholes, very, very few ways to get around it.
Now that you say that, when I used to do audit and I had to audit one of the casinos, I do remember that whenever they do their counts of the machines, gaming board representative had to be present.
Yes, ma'am. And however long it takes, they're going to stay there. Because I've had to stay in the cage with them. then they count everything, all your coins, all your cash, all of it. But that is the extent in which they regulate.
Oh, wow.
Yeah, they know exactly what you're doing when you're doing it, because all of your machines, you cannot have a machine that any person in this country is playing on that has not been approved by the gaming board. They're all listed. They all come from specific vendors. They are very, very, very strict. But it helps keep us as a country off the blacklist, because you come in, you think, oh my God, gaming is high risk and whatever. But when you see the rules that govern the industry, then you take comfort. I know I took comfort in knowing, okay, it ain't much could go wrong because these are some very tight rules. You can't have a gaming account if you're a licensee. There are lots of things you cannot do as a licensee of the gaming board. I say an employee, I say licensee.
But even a few years ago, when I can't remember exactly what it was that happened, but I know that there was one number house where any of the employees that had an account with them, they had to let them go.
Because you cannot have a licensee with an account.
Yeah.
But it gives the industry great comfort in knowing that these things are in place. Yes. So that is a part of the Bahamas AML Cftpf regime that a lot of times people don't hear about. People think, oh, people gaming, oh, they thiefing, or they say that. Nuh-uh. It is very difficult. I wouldn't say impossible, but it is very difficult to get around certain procedures and policies in that sector. It is easier, in my opinion, to get away with something in the banking, straight banking sector.
Was part of it too how they stopped using or I think they maybe told people to stop using it, I'm not sure. Using the Island Locker or the gaming accounts as a bank?
That part of it is actually regulated by the Securities Commission, but let's be honest, what they couldn't stop it, you could only limit it. So what you do now, they have policies in place where you can only take off so much money in cash, unless you win. So if I could deposit money in your bank account if I choose, so people could still deposit money on your gaming account if they so choose, but they limit how much you could withdraw every day, because that would limit the use of it as a bank account. But you can't tell somebody you can't deposit money on my account. I remember at one time, a couple of years ago, I think one of the banks had tried it, like, oh, you can't deposit on somebody else's account. And I was livid because my kids were off to university. And I was thinking, okay, so please tell me how you expect my children to get their allowance if I can't put monies on their account as their mom. Like, make it make sense. Obviously, all of the banks roll that back because we live in a society where we're very close knit, right? My mommy sent me to the bank to do our transactions all the time. Yeah, so when I can send her the same thing, how do you tell me I can't deposit onto someone's account?
Make it make sense.
None of y'all was around when that happened? That was less than 10 years
I
ago.
was in Canada and I couldn't get my funds. My parents couldn't send it. So I totally understand.
I recall that too.
Yeah, I make plenty noise and I know my rights. So I'm like, I'm about to deposit this money on my child's account. Now you all figure out what is what, but the money gotta get there.
It have to make sense.
So Guernsey, it has to make sense. Like policies and procedures I get because I'm a compliance consummate. However, it has to make sense. I'm not about to allow you as a bank to cause me to not be able to do something that's not criminal. Show me where it's criminal, and then yes, I will concede. But until then, if it's just a bank's policy, every policy in every institution has somebody that can override it. And usually that's the person you ask for, right? Let me see the manager. Let me see your MD. Let me see your CEO. No, because if you could give them, right, a sensible argument as to why the transaction should happen, then albeit I'm not sending a wire transfer if I can just make the deposit to my daughter's school. I mean, to her account. It's not like I'm sending money to school fee or something like that. I'm trying to give her allowance. What are you going to do? Let her starve?
Yeah, it's crazy.
So all of the banks rolled back that policy because it was nonsensical in this environment. We are too closely knitted in the Bahamas for that to happen. We are people and family living on other family islands, and you have to get things done. So Guernsey has a strategy as well on money laundering and terrorism financing. And if you notice, the UK is split. You will see that in this unit, it's split out into Guernsey and Jersey because those two are also actually international financial centers as well. Now we talked about STRs and tipping off. We also have to talk about the filing of them. I think we briefly touched it, but when we file an STR, what happens to that STR? Anybody could answer me. I'm not talking about you filing it. I'm talking about in general. What's the process?
Is it reported to FIU, Financial Intelligence Unit?
Yes, and then what else happens?
It has to be looked, and they would review it. Well, first, I guess they'll let you know that they received it and ask you to give them some time, and then they'll get back to you because they'd have to investigate it to see if it really is something that looks as if it was something suspicious on their end.
What else happened? You're down the right road. What continue?
And then whilst they have it, yeah, I think you would be able to transact on the accounts. You have about a month. Yeah.
I know they present their findings.
I feel as if it's something suspicious and my MLRO reviews it and she agrees to file it, it may not necessarily be suspicious on their end. So if it is suspicious on their end, then of course they will act on it. But if it's not, they'll respond to you and let you know that, this was nothing out of line here.
If it is suspicious, they take it to the police, right? Let the police conduct their investigations, right?
Correct.
Continue on. And they go to court from there.
They escalate, they escalate it. But you have some SARs that are filed and you would get a response that, hey, nothing wrong with this, continue on, business as usual.
And then you'd also have some, you don't necessarily have to have the account trading or the account active, because if there is, and I've done it because I've been an MLRO, if I'm uncomfortable with a client's request, especially if I've filed an STR, I would go back and I would ask the FIU, please give me an order where I can freeze the account, because they can do that, right? So I would request from them a freezing order, which means I will be within my legal rights. The clients can't really come after me if I have from the FIU a freezing order. If the freezing order needs to be extended and they are still working on their investigation, they can go to the court ex parte in the judge's chamber, and they can give me an even longer time, because the Supreme Court can give you more time than the FIU to freeze the account, right? So you have to understand that there are legal ramifications for doing certain things. But when you file an STR and a client is requesting a transaction out of the account and you're uncomfortable with that, just know that you are well within your rights to go back to the FIU and ask them to give you a freezing order, provide you with the authorization from their office to freeze the account. Now, sometimes they will tell you continue on because they want to watch it, and that's fine. But if you are uncomfortable or the institution is uncomfortable based on whatever it is that you would have reported to them, they will definitely give you a freezing order. And like I said, if their time is up and they're still working on an investigation, they will go to the Supreme Court, which is where they'd have to get the permission from to freeze it for an even longer period of time. The FIU in the Bahamas does not have the power to investigate. What they do is collect information, analyze, and then they send it to the police who has that power. Now, there are different types of FIUs, but that one is specifically how the Bahamas FIU operates.
So, Ms. Sons, I have a question. When the freezing orders already would have already been given, wouldn't the client be aware of that? Wouldn't it be like sense of tipping off a little bit? Because they can't do any more like transactions anymore.
They may know, but it ain't for you to tell them, right? So you just have to try and make excuses as to why they didn't get that transaction yet. They could be mad, but if you've already filed an STR, right? And you decide, even though you're uncomfortable, decide to help them with that transaction, guess what? You could be complicit. Yes? Because if that transaction is found to be one where it's terrorism related, it's proliferation financing related, money laundering related, then you as the MLRO and the person who has reported the matter in the form of an STR, you're already uncomfortable with the transaction if you report it. Right? Obviously, something suspicious happened for you to be able to report it. And if the FIU is taking longer than expected, then if the client gets upset, that's fine. Tell you, management have to figure out a way to tell them whatever. But you should not be doing any transactions over that account until and unless, because sometimes the FIU will tell you, release the transaction. But you have that in writing from them. So if anything happens, they can't come back and say that you were complicit. You were following orders. And that's why I say, make sure I reach out to them. I had a very good relationship when I was an MLRO with the people at the FIU, especially with the deputy people, persons, because normally it would be that person that I would deal with. And I would call up and say, listen, I got this, and that. I'm comfortable with this one. I need you to send me a freezing order. And they will more than likely send the freezing order. And if I see the time is going, because obviously I'm going to have this diarized, right? As an MLRO, because I know I only have a limited amount of time for the freezing order. Then I go back to them, I say, listen, I'm still uncomfortable. The client is asking for the transaction. I need you to go to the courts, and they can just go in the judge's chamber and get it done. Normally, a Supreme Court judge will sign off on it because it's coming from the FIU. They're asking to keep the account frozen, and ain't no judge is going to say, oh, no, let it go. Because if the FIU is coming to say, this is something that we don't want to happen, judges, they usually sign. And once you get that from them, you in the clear.
Yes, sir.
Ms. Sands, you mentioned something about the fact that, hello?
I'm listening.
Hello? Oh, sorry. You mentioned something about the fact that they're, something about their powers in terms of them being able to go in and do certain things. So it sounds as if their powers are pretty much limited in terms of investigation and enforcement and that sort of thing.
No, it's limited in investigation.
Okay.
But they have no enforcement powers at all.
Wow.
And that's why the freezing order is your best friend. If you send them, an STR, the enforcement comes in with the police. And if you are familiar with the FIU, it's usually headed by an officer.
I was trying to find out, like, I was trying to figure out why their response turnaround time sometimes it takes so long.
Because they have resource constraints. If you think about it, first of all, it's a government agency, right? That's the first thing. Second of all, you're getting all of these reports. You heard Mr. Brown say they write them every day, pretty much. In retail, most retail banks write them every day. You only have, let's just say, 10 or 15 analysts. You're going to be inundated with work. And they all have to be investigated, because the one you might say, oh, that don't look like nothing, that might be the very one that turns out to be something, right? So when you think about it, based on what they say, it's always been a resource issue. You only have so much bodies to look at so much information.
Right. Yeah, that's been my experience too, working in commercial banking, and working in the science department. It takes a very long time before you get response back.
Well, if it makes you feel any better, it takes a long time in offshore banking as well. So commercial banking ain't special. It just takes them a long time, period. But when you hear about the number of STRs that the FIU get every year, then you would understand and you'd have an appreciation that, hey, they have, from what I know, they have less than 20 analysts. Ain't nowhere in the world all of those things could be looked at in 48 hours, 5 working days, because you could be on one case for days.
Well, that doesn't make any sense to only have less than 20 analysts. Well, it's such a crucial function.
But it happens, yeah.
So what would be the bank stance on that now? Because don't the banks have a certain amount of time? They need to know, like, we need to offboard this customer because this customer is a risk.
You can't offboard a customer if you have presented the FIU with an STR. You need permission.
I know that. I know that. That's what I'm saying. The length of time for them to get back to you.
It doesn't matter. It doesn't matter. You can't close it. If they take 3 years, and they've taken in an institution I've worked with, they've taken 7 years.
What?
But you can't.
That is crazy.
You can't do anything.
I see a situation like that for true, whereas the customer was sending the bank to court because the bank didn't get a response back yet. And they wanted to offboard the customer. Everything was all freeze, but the customer ended up sending the bank to court at the same time. So the bank was waiting on their response.
Trust me, the customer has to win.
I don't know.
Can't win because the bank is within, as long as the bank gone through the process. I'm telling you, if you have a freeze order from the Supreme Court, no judge is going to go against that. The customer will never win. Because for it to be frozen so long, that's way past the FIU's remit. They had to have gotten a freeze order from the Supreme Court.
Mariva, wow.
The FIU cannot freeze an account indefinitely. As a matter of fact, I think they only have 3 to 5 days. Anything over that, you have to go to a Supreme Court judge. And like I say, you're seeing them in chambers, so ain't nobody even know what you're doing. This ain't no case. You just go into them and, you explain, somebody from the FIU explain, blah, 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 this is what they need. They sign off. But once you have that as an institution, ain't no customer in this country will win.
Because it's almost like you trying to build a case against the law.
Pardon?
It's almost like he's fighting a case. He's trying to present a case against the law. And he doesn't.
You can't go to the courts and to complain, and it's the courts who have you tied up. You just don't know it's the courts who have you tied up because we can't tell you.
Right. You don't know the depth.
Ex parte.
Yeah.
Exactly.
Mm-hmm. I love ex parte.
When they send those freezes, when they do the freezing, it don't only affect like just your account. If you get credit cards and all of that stops.
Exactly.
All of that.
But you could only get that from a Supreme Court after 3 to 5. I think it's between 3 and 5 days. After that, trust me, they go into the judge and they get that sign. So that's the bank could do, because the bank cannot unfreeze the account because the Supreme Court order is in place. The bank can't do nothing, and the customer can't do nothing.
The bank somewhat takes a loss though.
I got it.
How they take a loss? Because they lose the customer? How they can take a loss?
With their additional products the customer holds with the bank. Like once that account go on freeze and they can't do anything, and let's say the customer get credit cards 10,000 here, 12,000 there. Those cards on freeze too, but the cards, they still got to get the payment, and the customer is not paying because the card is on freeze. So the bank now have to write that off.
That's part of doing business for the rest of the things where they winning. Think about it.
But you know, they don't like take losses on no business like no business like to take losses.
No,
Right, but if you think about it, like I tell you, I'm going to challenge you all on this class. Think about it. You prefer to take a loss with a $10,000 credit card or take a loss from the Supreme Court doing something to you? Which one you prefer?
I think they'll choose the greater. But they always do. They always will choose the greater.
They can choose the what?
They can choose the greater risk. The
What is
risk.
the greater risk?
The lesser risk game.
The lesser risk. The lesser risk, I mean.
Yeah, the lesser, because
what is $10,000 towards versus your license?
Yeah, they'll choose the lesser risk.
Exactly.
So I have a question. If that client is being marketed and that client has current credit facilities, won't they pay them off and then give them the balance of their funds? Do they have the rights to do that?
It depends. If the account has been frozen by the Supreme Court, you can't do nothing. You're in limbo. Now you can go back. The bank has the right to go back and ask the Supreme Court through their attorneys to be able to do X, Y, and Z. However, the FIU also has to state their position. If the FIU has no objection to the bank paying, getting paid off, and then just freezing the balance, that's a conversation that the FIU and the attorneys from the bank have to have in front of the judge. You can't do anything with a frozen bank account once you have a order from Supreme Court justice. Nothing. And why you want to do anything.
Ms. Sand, so what is the balance between the mere inconvenience of someone doing business versus someone, like someone having a suspicion, I put that in quotes, when it's not even grounded in facts, but in terms of the effect, like what is the balance between that for like the mere businesswoman or the businessman?
Let's put it like this. When I'm providing you a service, if I think you're going to bring harm to my reputation, I'm not concerned about balancing your business at all. I'm not interested in how you balance your business. I'm interested in the reputation of my institution because I do not want my reputation to be used to launder funds, 1. 2, if the suspicion is not based in fact, then the investigation won't take very long because it's a process. It doesn't always get to the FIU. However, if your MLRO is suspicious, then obviously that there is something that would cause them to write that report. So it has to be something. It's not just going to be arbitrary, right?
Right. Okay.
You don't get the SDR doesn't have to go. An internal SDR can stop at the MLRO's desk because the MLRO can say, hey, I've looked at this, I've done my own investigation, and I don't think that this is something that needs to go to the FIU. However, let's watch this account. Let's put this account on a compliance block. So every transaction that goes through that account will have to be unblocked by compliance, which means somebody in compliance has to view the transaction and approve it prior to it taking place. That has happened all the time in my experience. We do that all the time. Especially in the international banking, offshore banking, whatever you want to call it. We do it all the time. We put clients on lists to watch them, right? And so every time they request a transaction, we do research to find out if what they're asking for is legitimate. And then we decide if we want to release the transaction or not. We're well within our rights to do it as a bank. Because when you signed our policy and our terms and conditions form, you agreed for us to do what we have to do.
Okay, so Ms. Sands, I just want to ask in terms of my understanding of this, an MLRO would be someone who is like independent to a certain degree, that person, well, compliance officer would be more of an independent personnel within the organization, right?
Well, an MLRO definition is supposedly a senior person who can make decisions as it relates to filing SDRs, right? An MLRO's role and their title is one that they're senior enough that they report directly to the board of directors. They also have a dotted line to the CEO of the company. However, you have to recognize that an MLRO, to get that position, would have to have some analytical skills, number one. Number two, they are senior enough to work as an independent person.
Right, right.
However, you still have a dotted line to your CEO. So then you have a balancing act, right?
Right, that's hard to come by though, because that's a hard balance, because you're supposed to be independent. You have that analyzation, like analytics, you know, expertise, but then it's like to the CEO. I mean, because okay, let's just say an MLRO is doing their job, but in essence of doing their job, they're costing the firm money in terms of time and transactions, but then they're doing their job and then there's no grounds on the basis of their suspicion. I'm just like, where does...
No, Denisha, what you mean there's no grounds? It may not be exactly what they think it is, but if you have a suspicion, it doesn't have to be grounded.
I understand that based on the case law, Masans, but my grapple with it is, if your suspicion and in the end it turns out not to be grounded, and it's costing us money in terms of time,
you're covering yourself basically.
Then I need
to... No, but Denisha, you have to think about it. There's a balance in doing business. Do you want to pay the regulatory fines and penalties? Or do you want to take 2 or 3 days to get something sorted? You have to make a decision as a business.
Okay, yeah? I'm looking at it as mere inconvenience by having you here as an independent. And okay, you claim you have this suspicion, right? But then the suspicion is causing me money. And then in the end, it turns out it's no suspicious act. You know, it's like the regulatory body or the court doesn't deem it, just saying as suspicious act. There's no money laundering done. There's no evidence. But I'm looking at it, Ms. Sands, and just being, I don't like to say devil's advocate because I don't like to give the devil so much credit. But in terms of just thinking, in terms of the mere inconvenience of it all for a person doing business, like where is the balance? I understand in terms of fines of the government or breaches or penalties, but you know, what if you have an MLRO that in their view thinks everything is suspicious that's causing the company money?
So Denisha, let me tell you from a practical standpoint. I run a company and I have a compliance officer that reports to me. She also reports to the board, but hey, I'm sitting on the board. Hey, I'm the resident director. So let's put it like this. For me as a CEO, I would prefer the inconvenience and whatever cost comes along with, even if I have to lose a customer, than to face a regulatory fine or penalty, or to face the possible reputational risks involved with the transaction. I prefer for that SDR to be properly investigated. Even if nothing comes out of it, I would have covered myself as an institution. So this is why an MLR position is so important. And this is why you have to have senior people who have analytical skills. Because at the end of the day, no company wants to be non-compliant. None. Because the cost of being compliant is definitely cheaper than the cost of being non-compliant. And by being non-compliant, I mean, if something comes across the MLR's desk, she thought it was suspicious, and let's just say the business head told her, no, you can't report that because that's our big client and we can lose money and all of this stuff. And that same transaction comes back to bite that institution in the butt. Trust me, the cost of non-compliance is always greater.
Okay. Okay.
You work in the regulatory space. I could tell you, regulators have no tolerance when MLROs are fettered in their discretion to report STRs. No tolerance for that.
Okay.
Now I've known MLROs that have gotten fired for filing STRs when their management told them not to, but I also know MLROs that have gotten paid out because they've gotten fired and they have sued their companies and won.
Wow. Okay. All right. That's an interesting twist.
You were going to say something, Ms. Shepherd?
Yeah, curious.
Yeah, I've been doing this for a long time.
Tanisha, I understand your question was around when you said where's the balance? Where's the balance in terms of from the institution perspective or from the client perspective in terms of
I was looking at it more, Ms. Hepburn, Donna, from the client's perspective, like the banks will always win. You know, that kind of way? Can't go against the bank, but where is the remedy or recourse for the everyday businessman or everyday businesswoman? You know, where's the balance where they're doing legitimate activities, but it's like the parameters around it is so stringent that yeah, that's how I'm looking at it.
Yeah, but before an STR is filed, there's certain, like the customer service officer, whoever is looking at the transaction, they would have to do certain probing. And when that probing is done to satisfy their curiosity or to satisfy certain questions, they would ask the client to produce certain things. Like, for instance, if you're saying this money is coming from a sale of a property, then bring me some evidence to show that the money is coming from a sale of property. Now, the STR is filed on the basis that you cannot produce or you're not satisfying the questions. You're not answering the questions that is being asked. But an STR is not just filed out of the blue. Like, you have to do certain probing. So the client has the chance or the opportunity to produce certain documentation to prove that their business is legitimate. Or
so they have an opportunity to respond.
Right. You have to do so, but it has to be discreet. It cannot be like, I need to know where this money comes from because I'm about to file this, whatever. But you do certain discreet probing so that the customer doesn't know that you're trying to find out this information on the basis of you want to file an STR. I mean, the science could correct me if I'm wrong.
Yeah.
Can I just add a little bit to that, please? To what Donna was saying, and even when the STR is filed, it doesn't affect the customer unless the MLRO deems it legitimate. In terms of, let's say I'm a teller or an account opener or something within the bank. I probe the customer and I'm not getting the information that Donna mentioned a while back. And so I then discreetly file the STR and it goes to the MLRO. The customer's not aware of that. So they're not impacted in any way. The MLRO would then do their investigation, and that, based on their determination, the customer is then, I guess, questioned further, but they're not involved or they're not affected initially, unless it's something worth taking further.
Okay, but are they impacted, Ebony, in time? Like, they're not aware, but are they impacted in terms of time delay? That's what I'm getting
only
at.
unless a transaction, Denisha, only unless a transaction cannot be processed because of the MLRO's feeling of discomfort. So as long as the MLRO is saying, okay, this is a suspicious transaction, but I'm doing my investigations, but I'm comfortable to let this specific transaction take place, that's fine. But when there's a level of discomfort from the MLRO and they have either filed an or is in the process of filing an STR, the customer is only going to be impacted if the account is blocked.
Okay, okay.
Now, sometimes, based on what Donna was saying, you don't always have an opportunity to go back to the client, because if you go back to the client and ask questions, you are going to unintentionally commit tipping off. So what happens is the MLRO would be the person along with the front office person, if possible, trying to find out information discreetly. Because once you go back and ask the client for certain things, they're going to have some knowledge that, hey, why you come back and ask me for this?
Okay, okay, okay.
So as a business, you have to balance your risks, right? I told you from day one, I balance my life risk. So as a business, you have to balance your risk. You either take the risk of not filing and something happens, and you as an institution take the heat from your regulator, with fines, penalties, or whatever. And remember now, the MLO is a statutory position in law. You have personal liability. So if you neglect to do your job in the proper way and you allow a specific transaction to take place, knowing full well that you're uncomfortable, you in turn can be held liable for your decision.
Personally?
Yes. Wow. You have personal liabilities in MLRO. Didn't I tell you from the first class how serious this position is?
Thank you, ladies, for your clarification. Thank you so much.
So I've been talking for a very long time. Let's take a 10-minute break and we're going to come back and finish unit 3. And when we end, we can have the conversations around what we discussed last week. Okay, so let's go until 8 o'clock. I need to get some water and we will be back in, well, 9 minutes now.
Okay.
Thank you. Okay.
Hello.
Hi.
I'm back.
Okay.
I'm back. Sorry. Took a bit longer than I expected. So we just need to cover before we end. You saying something, Estelle?
No, I didn't.
Okay. We just need to cover, if you look at page 130, you'll see that there are alternative national AML CFT models. And 7.1 speaks to the mens rea requirements for substantive money laundering offenses. Now we got a bunch of lawyers on here. So please, anybody, feel free to tell us in layman's term what that means, the mens rea requirement.
Mens rea, you had the
So let me
intention, motive.
Right, so another attorney, give me the other part of mens rea. Rodrika, Rashada, David.
Referring to the opposite side. The opposite of mens rea would be the actus reus.
Actus reus, right.
Actus reus, the physical.
Right. Thanks, Joey. Thanks, Rodrika. Right, so if you look in this, I guess, subsection, you'd see that different countries have different models, and it's called Alternative National AML CFT model. We talked last week about the Bahamas and inclusive framework. So you just have to look through and see how the international standards are implemented. And most of these countries are European countries. They're not specifically Bahamian, but as we discussed last week, there is a way in which we have a framework in the country, right? That governs AML CFT regime. So just make sure that you would have read familiar with what's expected for you to know. Now, can somebody read the learning outcomes for me, and we can go and see if we actually know what the learning outcomes say we should know. The learning outcomes is on page 140.
To be able to describe the UK, Jersey, and Guernsey AML frameworks, the primary legislation, POCA, secondary legislation, money laundering regulations, the UK industry's own guidance, and the UK's FCA's handbook. Continue, or we go?
Read the whole thing, Felicia.
Okay. Understand the implications.
No, read all.
And understand the implications of the EU money laundering directives for the UK and other European financial services firms. Recognize the various money laundering offenses under UK law, including concealment and arrangement and tipping off, and the possible consequences of failing to comply with the regulation. Know what is meant by predicate criminal conduct and the mens rea. Understand the obligations and financial services businesses for reporting suspicious activity, while appreciating the slightly different rules that apply in various jurisdictions as to what constitutes suspicion. Be able to outline how AML CFT laws and regulations are implemented in various European countries.
Okay, cool. There's one thing on there that we didn't speak to specifically, even though we had a whole conversation around it. What does constitute suspicion in the Bahamas? Any of the attorneys could answer.
Sorry, could you repeat the question again?
What constitutes suspicion?
Is it like a gut feeling? Nothing so vague. It doesn't need to have grounds supporting it or substantiating it, even though that would be good, but it's more like a gut feeling or unction to disclose suspicion.
You can't use suspicion.
Would it be anything else?
Defining suspicion.
Something out of the ordinary.
Suspicion would kind of be like sort of knowing that the customer is operating outside of their normal transaction activity, if that makes sense.
Well, okay, so let me challenge that. Let me challenge that, Joey. What if it's just unusual?
Well, I guess the number of occurrences too, like, you know, the count salad man probably ain't gonna go over $100,000 per month, but this has now happened on 5 or 6 occasions. So let's monitor, let's watch.
So what is that thing that separates unusual activity from suspicious activity?
Evidence?
I would say evidence. I would say investigation. Yeah.
Right, conducting an investigation, right.
Because a customer could possibly go outside of their regular investigation. Then you determine, hold on now, wait, this ain't adding up. This is now, it's crossed the line from being unusual to suspicious. And the central bank has that specifically in their guidelines. I was asking the lawyers because I was trying to see if you have something different in law. But I mean, from central bank's perspective is what I just told you all. Is there something different in law? Is there, I mean,
I don't think there's I mean, I'm not aware of anything in law that speaks to, I guess, the distinction between the two. But just for clarification, you're saying the distinction between unusual and suspicious is the investigation itself. So unusual in the sense that it's outside of, I guess, the parameters or the scope of what the client normally does, but then going a bit deeper and doing an investigation, which then pinpoints that it seems more so suspicious, right?
right. So when you have an unusual transaction, you kind of want to watch it because it just could be a one-off, right? Because we have a lot of times when you just do a one-off transaction. However, when you do your investigations to say that okay, this transaction is not within their parameters, the Estelle, can you put your mic on mute for me, please? I'm getting a feedback. Thank you, Ava. Thank you. Then your investigation is going to lead you to a path of whether this is just unusual, investigate it, and the transaction ain't plausible. It don't make no sense. It should not have happened or should not be happening. That is how you get from unusual to suspicious. Because you can have an unusual transaction and do your investigation, and you recognize, oh, somebody died and this client inherited this fund. So that's a one-off, right? If you see that, you can always go back to the client and ask them for supporting information. However, if you see things happening outside of the parameters of the client, and it makes no logical, business, or ethical sense, then you say, hold on now, wait, something wrong here. Understand?
Right.
Carol?
And at which point then you would file the STR.
You ain't filing, you telling it to your MLRO. Remember now, if you working inside an institution, it's not, unless you are the MLRO, you're not the one filing. So what you're doing is
Right.
you're providing your MLRO with an internal STR, or some banks call it UTR, unusual transaction report. And your UTR should include the fact that you would have already done your prior investigation before you sent it to the MLRO, because it's unusual but based on what you have found, you deem it to be suspicious, so you're escalating it. Now, they still have to do their own investigation. However, you would include all of that information in there, which will give them a foundation from which to start.
So, Ms. Sands, you must do your own internal investigation.
Now, this isn't from retail. This is like from the international world, because most retail people don't have that. They're on time sensitive, they're doing transactions all day. But when you're in international, you can do your own, research on the client, because you could sit down to your desk and do the research.
Yes. Okay.
But people like, I think it's Mr. Brown, if the transaction out of the client's parameters, I think the banks just tell them, straight up, report it. It ain't for them to do the investigation. It's for the MLRO to do it.
Yeah, for the most. And sometimes, to be honest, you could quickly browse the customer's history, like if it's outside of their EMDA, their expected monthly deposit, and you would realize like, all right, this customer possibly had switched jobs, because you'll see like a trend, and then you just would contact them, and you don't even have to go through all of that once they provide the information. But sometimes it'd be very simple, but outside of that, we advise you we just send it out.
Okay. Send it out as an external.
Yeah, we don't sit down and say really do in-depth
internal
research.
Okay.
No, they send it out to the MLROs, because the MLROs don't be sitting in the branches.
Oh, I didn't know that.
But Tanisha, you only can have one MLRO for a
but
company.
I didn't know they were like
branches.
Yeah, okay.
See, so that's why it's different from retail to international, right?
Right.
Because then you have maybe 6-10 tellers, all them feeding that information to the bank's MLRO, which is one person.
Okay.
Quick question. Could an organization have multiple MLROs under its umbrella?
And if they have multiple licenses, yes. If not, then no, because you have one specific person that's responsible to the board. You have one specific person that the FIU and the regulator would approve. So if you are a conglomerate and you have a financial services portion and an insurance portion and something else, then yeah, each of the specific business lines, because they would have a specific license, yes, you could have different MLROs. But if you're just one licensee, you have one MLRO.
So for the bank, they have just one?
Yeah, because remember the bank have one license.
So
they're one entity. They have different branches, which is different than having a license.
So that one person dealing with, because one branch probably have like 5 tellers. So they dealing with.
This is why they have a department, right? They have compliance officers, but you still have one MLRO.
Oh, okay, yeah.
So, but you have compliance teams, right?
Yeah,
but one MLRO. The law allows one MLRO per entity. And that's because you have to have somebody to point to. I tell you that's a function in law, right? That's a position in law. So you can't say it's two of us. No, you are it. One CEO, right? Now you may have co-chairmans and co-this, but you don't have 2 CEOs.
Wow.
So it's the same thing. It's one person per licensed entity. Okay, so
I was thinking the MLRO held the license, but now I understand it's the organization that is granted a license to have an MLRO. So now it makes sense.
No, it's the organization that has a license. And so that organization has to write to the central bank or the Securities Commission, telling them that this is the person that their board of directors have approved to be the MLRO and they submit all of the information because there's an application process. Now, when you submit that to your regulator, the regulator will come back and say, yes, this person is approved. We deem them fit and proper. If the central bank or SCB does not deem them fit and proper, they tell you that they will not accept them or they accept them on certain conditions. So that's the process.
Okay, all right.
It's not really a license for the MLRO, it's a license for the entity itself.
Right, okay, thank you.
Anybody else have any questions? No?
So Ms. Sands, is one entity per MLRO?
Right, in terms of, okay, you know, some companies have a group of company. So back in the day, Credit Suisse had maybe like 9 different licenses, but they were all under the Credit Suisse umbrella, right?
They were subsidiaries, right?
No. They were separate entities.
Okay.
They weren't subsidiaries. Subsidiaries, yes, under the main Credit Suisse in Switzerland, but in the Bahamas, they had separate licenses.
Okay.
So the trust company operates separately from the bank. Then the bank at one point had 2 licenses. There was a bank and then there was a Nassau AG. So all of those licensees could have had an MLRO.
Okay.
Because it's a specific product line that they were in, right?
Right. Thank you for clarifying.
You're welcome. Anybody else? Any questions? No? Okay, give me one moment.